Canada's anti-spam law is about much more than just spam. It also regulates the installation of software. Like the rest of the law, it's complicated and convoluted and has significant penalties. If you're a software developer or an IT admin, you definitely need to know about this. Hi, my name is David Fraser. I'm a privacy, internet, and technology lawyer with the Canadian law firm McGinnis Cooper. I also teach internet and media law at the Schulich School of Law at Dalhousie University. In this channel, I try to provide educational and informative content about Canadian privacy and technology law. You should check out the full disclaimer below, but you should also know that this law is hard to understand and hard to interpret. It also carries huge penalties for non-compliance. If you're potentially affected by this law, you should seek qualified legal advice. So we're talking about Canada's anti-spam law. The official title is much longer, and it also includes 2 sets of regulations to make it more complicated. Now, despite the snappy title that most of us use, Canada's anti-spam law, it's about more than just spam. It has often overlooked provisions that make it illegal to install software on another person's computer or cause it to be installed without their consent. It was clearly put into the law to go after bad stuff like malware, viruses, rootkits, trojans, malware bundled with legitimate software, and botnets. But it's not just limited to malevolent software. It potentially affects a huge range of software. So here's the general rule from Section 8 of the Act. A person must not, in the course of a commercial activity, install or cause to be installed a computer program on any other person's computer system, or having so installed or caused to be installed a computer program, cause an electronic message to be sent from that computer system, unless A, the person has obtained the express consent of the owner or unauthorized user of the computer system and complies with subsection 11.5, or the person is acting in accordance with a court order. Let's break that down. The first part is that it has to be part of a commercial activity. I'm not sure they meant to let off people off the hook if they're doing it for fun and giggles. The commercial activity part is likely there so that the government can say this is justified under the federal general trade and commerce power of the Constitution. They could have used the federal criminal law jurisdiction, but then they'd be subject to the full due process and fairness requirements of the Canadian Charter of Rights and Freedoms. And the government did not want to do that. They'd rather it be regulatory and subject to much lower scrutiny. Then it says you can't install a computer program on another's computer without the express consent of the owner or authorized user of the computer. The definition of computer system would include desktops, laptops, smartphones, routers, and appliances, or cause it to be installed. The express consent has to be obtained in the manner set out in the Act, and I'll discuss what that looks like later. It also additionally prohibits installing a computer program on another's computer and then causing it to send electronic messages. This makes the creation of botnets for sending spam extra bad. The definition of the term computer program is taken directly from the Criminal Code of Canada. It says, computer program means computer data representing instructions or statements that, when executed on a computer system, causes the computer system to perform a function. In addition to defined terms, there are some key ideas and terms from the Act that are not well understood. It talks about installing a computer program, but what that is and what that means has not been defined in the legislation, and the CRTC hasn't provided any helpful guidance. I would think that running malware once on somebody's system for a malevolent purpose would be captured in the definition of install, though it likely also is in the criminal offense of mischief in relation to data. But what about downloading source code that is not yet compiled, or then compiling it, or causing it to be compiled on a system when it was already there? It's certainly possible to load up software and have it ready to execute without it being conventionally installed. Does it have to be permanent or show up in your installed applications directory? I simply don't know. There's also the question of who is an owner or an authorized user of a computer system. If the device is leased, the leasing company likely owns the computer, and we've certainly seen reports and investigations of spyware and intrusive software being installed on rented and leased laptops. My internet service provider owns my cable modem, so it's apparently okay if they install malware on it. Not that I expect them to. For authorized users, it means any person who is authorized by the owner to use the computer system. Interestingly, it's not limited by the scope of the authorization. It seems to be binary. Either you're authorized or you're not. There's some scenarios to think about when considering owners and authorized users. For example, if a company pre-installs software on a device at the factory or before ownership transfers to the end customer, that company is the owner of the device at that time and can install whatever they like on it. Many companies issue devices like laptops and smartphones to employees. Those employers own the devices and can install any software they want on them. But increasingly, employees are using devices that they own for work-related purposes, and employers may have a legitimate interest in installing mobile device management and security software on those devices. Unless there's a clear agreement that the employer gets to do so, they may find themselves offside this law. So in short, it's prohibited to do any of these things without the express consent of the owner or authorized user. First, install a computer program of any kind. Second, cause a computer program of any kind to be installed, such as hiding or bundling additional software in the installer that the owner or authorized user has installed. We sometimes see this when downloading freeware or shareware, and the installer includes other software that the user didn't ask for. Third and finally, or cause such a program that has been installed to send electronic messages after installation. Of course, someone who is the owner or authorized user of the particular device can put whatever software they want on the device. These rules only cover installation by people who are not the owner or the authorized user of the device. There are some exceptions that people should be aware of. It's common to install software and have it automatically update. This is okay if the user consents to the auto updates. But that probably doesn't apply if the update results in software that does very different things compared to when it was first installed. There are some cases where consent is deemed or implied. For example, counsel deems users to consent to the installation of the following list of computer programs if the user's conduct shows it is reasonable to believe that they consented to it. And it's a weird list. At the top of the list are cookies. To start with, anyone who knows what cookies are knows they are not computer programs. They are text files, and including them on this list tells me that the people who wrote this law may not know as much as you may hope about this subject. It then includes HTML code. Now, HTML is hypertext markup language. I suppose it is data that represents instructions to a computer on how to display text and other elements. I guess the next question is whether this includes variations of HTML, like XHTML. I don't know. But if HTML is a computer program, then so are fonts and Unicode character codes for emojis. Next, it refers to JavaScripts. Yes, it says JavaScripts. That's what it says. We're told by Industry Canada that this is meant to refer to JavaScript, which is completely different from a Java script. Not only could they have made such a stupid mistake, but maybe they could have been more clear about whether they were referring to JavaScript run in a browser or other scripting languages run in browsers that have their own sandboxes, or were they referring to something else? That's simply not clear. Next on the list are operating systems, which seems very perverse to include. The operating system is the mostly invisible layer that lies between the computer hardware and the software that runs on top of it. Changes to the operating system can have a huge impact on the security and privacy for the user, and much of it happens below the surface. And there's no clarity about whether an operating system on this list includes software that often comes bundled with it. For example, when I replace the operating system on my Windows PC, I get a new version of a whole bunch of standard software that comes with it, like the File Explorer and Notepad. It would make sense that a user who upgrades from one version of macOS or Windows to another. But I could make an open source operating system distro that's full of appalling stuff, in addition to the operating system. Is that intended to be captured? And finally, it says any program executable only through use of another computer program for which the user has already consented to installation. Does this include macros enabled in Word documents? I'm not sure. Now, it does make sense to have deemed consent in some situations or implied consent in some situations, but we could have used a lot more clarity. What were they intending to get at? There are also some exceptions to the general rule of getting consent, two of which are exclusively reserved for telecommunications services providers, and a final one that relates to programs that exclusively correct failures in a computer system or a computer program. Now, this is understandable, but this would mean that a telco could install software on my own personal computer without my knowledge or consent if it's to upgrade their network. That seems a little unreasonable to me. It makes sense for them to be able to update my modem to which I connect to their network or through which I connect to their network, but a personal computer seems outside that category. So how do you get express consent? It's like the cumbersome process for consent for commercial electronic messages in counsel, but with more. When seeking express consent, the installer has to identify the reason that they are seeking consent. They have to provide their full business name. They have to provide their mailing address and at least one of a telephone number, email address, or website URL. If the consent is being sought on behalf of another person, they have to say whose consent they are seeking. A statement that the user can withdraw their consent for the computer program's installation at any time, and a clear and simple description in general terms of the computer program's function or purposes. But if an installer knows and intends that a computer program will cause a computer system to operate in a way its owner doesn't reasonably expect, the installer must provide a higher level of disclosure and acknowledgement to get the user's express consent. This specifically includes the following functions, all of which, in my mind, largely make sense. If the program is collecting personal information stored on the computer system. If it's interfering with the user's control of the computer system. If it's changing or interfering with the settings, preferences, or commands already installed or stored on the computer system without the user's knowledge. If it's changing or interfering with data stored on the computer system in a way that obstructs, interrupts, or interferes with lawful access to or use of that data by the user. If it's causing the computer system to communicate with another computer system or other device without the user's authorization. If it's installing a computer program that may be activated by a third party without the user's knowledge. And finally, performing any other function that counsel specifies in the Act or the regulations, and we don't have any of those yet. Now, like the unsubscribe for commercial electronic messages, anybody who installs software that meets this higher threshold has to include an electronic address that is valid for at least 1 year so that the user can ask the installer to remove or disable the program. A user can make this request if they believe the installer didn't accurately describe the function, purpose, or impact of the computer program when the installer requested consent to install it. If the installer gets a removal request within 1 year of installation and consent was based on an inaccurate description of the program's material elements, then the installer must assist the user in removing or disabling the program as soon as feasible, and at no cost to the user. So how is this enforced? Well, counsel is largely overseen by the enforcement team at the Canadian Radio, Television and Telecommunications Commission. Overall, I see them at least making more noise about their enforcement activities in the software arena than in the spam arena. In doing this work, the CRTC has some pretty gnarly enforcement tools. First of all, they can issue notices to produce, which are essentially similar to criminal code production orders, except they do not require judicial authorization. These can require the recipient of the order to hand over just about any records or information, and unlike a criminal code production order, they can be issued without any suspicion of unlawful conduct. They can be issued just to check compliance. I should do a whole episode on these things, since they really are something else in the whole panoply of Canadian law enforcement tools. They can also seek and obtain search warrants, which at least are overseen and have to be approved by a judge. Before counsel, I imagine the CRTC was entirely populated by guys in suits, and now they get to put on raid jackets, tactical boots, and strap on a badge. I mentioned before that there can be some significant penalties for infraction of counsel's software rules. It needs to be noted that contraventions involve administrative monetary penalties. These are not punishments, but are intended to ensure compliance. And these are not fines per se and are not criminal penalties. That's because if they were criminal or truly quasi-criminal, they'd have to follow the Charter's much stricter standards for criminal offenses. The maximum for these administrative monetary penalties are steep, up to $1 million for an individual offender and $10 million for a corporation. The legislation sets out a bunch of factors that need to be considered in determining an appropriate penalty, including the ability of the offender to pay. There's also a mechanism similar to a U.S. consent decree where the offender can give an undertaking that halts enforcement, but likely imposes a whole bunch of conditions that will last for a while. Officers and directors of companies need to know that they can be personally liable for penalties, and of course the CRTC gets to name and shame violators. There is a due diligence defense, but it's a pretty high bar to reach. We've seen at least 3 reported enforcement actions under the software provisions of counsel. The first was involving 2 companies called DataBlocks and Sunlight Media in 2018. They were found by the CRTC to be providing a service to others to inject exploits onto users' computers through online ads. They were hit with penalties amounting to $100,000 and $150,000 respectively. The second enforcement action was in 2019 and involved a company called Orcus Technologies, which was said to be marketing a remote access Trojan. They marketed it as a legitimate tool, but the CRTC concluded that this was to give them a veneer of respectability for an ultimately shady undertaking. They were hit with a penalty of $115,000. The most recent one in 2020 involved a company called Note Solution Inc. doing business as OneClass. They were involved in the shady installation of a Chrome extension that collected personal information on users' systems without their knowledge or expectation. They entered into an undertaking and agreed to pay $100,000. I hope this has been of interest. The discussion was obviously at a pretty high level, and there's a lot that's unknown about how some of the key terms and concepts are being interpreted by the regulator. If you have any questions or comments, please feel free to leave them below. I read them all and try to reply to them as well. If your company needs help in this area, of course, please reach out. My contact info is in the notes as well. And of course, feel free to share this with anybody for whom you think it may be useful. Thank you very much for tuning in.